unwavering support of this lawsuit and for your commitment to protecting access to reproductive health care for low-income women. Thank you.
Thank you.
We have both been hoping for the day when we can say that this ill-considered rule will not be going into effect anytime soon, and it really feels good to know that that is true. And I want to also thank our wonderful partners at Planned Parenthood, the Oregon Medical Association, and the American Medical Association, and all of the 21 states that joined together in this lawsuit, in particular our co-lead New York Attorney General Tish James. Today's ruling by Oregon's Federal District Judge Michael McShane is a significant victory, not just for Oregon, but for all women in the United States. This nationwide injunction means that the Trump administration's cruel and arbitrary Title X Gag Rule will not go into effect on May 3rd, as HHS, Health and Human Services, that federal agency, had hoped, as that would have been the formality of 60 days after issuance of the rule. Doctors and medical providers around the country who work in Title X clinics will not have to censor what they say to patients or tell patients who ask for information about an abortion that they are not able to provide them with that information. Indeed, the Title X rule proposed by the President is madness, as remarked by the judge in his opinion. And through this lawsuit, we were able to help stop this madness. To give you a flavor of Judge McShane's 32-page opinion, he states in part, at best, the final rule is a solution in search of a problem, and it disregards the health outcomes of women, families, and communities in the guise of program integrity. The Gag Rule prevents doctors from behaving like informed professionals. It prevents counselors from providing comprehensive counseling. It prevents low-income women from making an informed and independent medical decision. At the heart of this rule is the arrogant, it's still the judge talking, by the way. At the heart of this rule is the arrogant assumption that government is better suited to direct the health care of women than their medical providers. It is significant that Oregon was not alone in this lawsuit. What was so powerful is that we were joined, as I mentioned, by 20 other attorneys general, including New York and again the American Medical Association and Planned Parenthood, which filed, the AMA and Planned Parenthood, a companion lawsuit the same day that we filed our lawsuit, and they were both heard at this preliminary injunction hearing last week. So we're very proud of this partnership, and it's an example of the work that state attorneys general have been doing together throughout the country along with other partners over the past 2 years. So last Tuesday in federal court in Portland, we were able to successfully outline to Judge McShane the harms that the Title X rule, if implemented, would have on low-income women. And included in our lawsuit were 36 declarations from public health policy experts from each state that joined us, from medical organizations, from doctors, and from Title X providers. And these sworn declarations of fact made a lasting impact on the judge. As he writes on page 3 of his opinion, the harms outlined in the record before me, should the final rule be implemented, are extensive and are not rebutted by the government. A review of the scores of declarations lead, this is him talking still, to the inescapable conclusion that the final rule will result in negative health outcomes for low-income women and communities. Now, last week, a federal judge in the state of Washington and a judge in California agreed with Judge McShane and independently from one another granted injunctions. The California injunction is not, at this point, a nationwide injunction. That's my understanding, but the Washington one is. California's applies